Yes, even though the majority of arbitration agreements are in respect of disputes which may arise in the future, parties to an existing dispute may also decide by means of what is called a submission agreement to submit their dispute to arbitration. This is where both parties recognize that their dispute will best be resolved through arbitration rather than through litigation. The law allows that to be done. It is important that before parties insert an arbitration clause into a contract or any agreement, they really understand what they are doing. There are certain matters which must necessarily be included in an arbitration agreement before it becomes a viable arbitration agreement. So the parties will need to be thinking about what is the scope of the dispute which we will settle through arbitration. How many arbitrators are we going to use? What will be the qualification of the arbitrators? How are we going to appoint arbitrators? In the event that there's a vacancy in the arbitral panel, how are we going to replace the arbitrators? And matters such like that. If these matters are not agreed upon and inserted in the arbitration agreement or the arbitration clause, there's a danger that once a dispute arises, the parties will disagree over these essential matters, and the arbitration agreement potentially may become pathologic, meaning that it may not be able to be enforced. Well, these days most of the courts are pro-arbitration, and so when they are confronted with a potentially pathologic arbitration agreement or a potentially pathologic arbitration clause, they try to save it. And so the attitude of the courts, by and large, especially with respect to international arbitration, which was the focus of the discussion over the 3 days, is to try to find a means of saving that clause. However, the reason why people choose to go to arbitration in the first place is to avoid contact with the courts. And therefore, if you badly draft your arbitration agreement and you need to go through the courts, then you are defeating the very purpose for which you signed on to an arbitration agreement. Legal practitioners and other professionals who want to engage in arbitration need to realize that arbitration is a science of its own, and therefore before embarking on any arbitral process, it is important that they study the art and science of international arbitration or even domestic arbitration to understand the nuances involved in the process.